And a H-1B is a non-immigrant classification based on which a person who is working in a specialty occupation, that is an occupation that requires the minimum of a bachelor's degree in a specific field, is able to petition with the USCIS, and once that H-1B, the employer petitions, and once the H-1B is approved, then the beneficiary can start working in that specialty occupation. And this most importantly gives the beneficiary the ability to work. So it's a work visa. So a specialty occupation basically requires, has to require the theoretical and practical application of a body of very specialized knowledge along with at least a bachelor's degree or its equivalent. So there has to be specialized knowledge, and there has to be a requirement of a bachelor's degree in a specific field. Just to name some, architecture, engineering, mathematics, medicine, law, education, all these could be specialty occupations. So the first thing is that the position should require specialized knowledge. The position should require a bachelor's degree in a specific field, not a bachelor's degree in arts, that is not specific, but a bachelor's degree in, say, electrical engineering. That is specific enough. No limit on filing transfers and extensions. There is a limit in new H1s. So if you've never been on a H1 and you're filing a change of status, say from an F1 to a H1 or an L1 to a H1, or if you're out of the country and filing H1 for the first time, then there is a limit on those kind of H1s. And the limit is 65,000 for bachelor's degree holders, and there's a separate limit, a cap for master's degree holders, which is 20,000. So total number of H1s that are allowed to be filed every year are about 85,000.
Right.
But numerous H1s are filed every year, much more than the limit, 3 times, 4 times. For example, the last year, about 300,000 plus applications got filed. This year, 400,000 plus applications got filed. So you can see it's not even 1/4, 1/5. The number gets picked out of the total number that's filed. So you can see what the actual demand is for the H-1B numbers, and there's been a lot of advocacy on increasing those H-1B numbers, but so far there has been no success in that front. But there are some H-1Bs, some H's that are not subject to the cap, and those are H's that are filed by exempt organizations, so organizations that are non-profit, governmental organizations, or educational institutes, so educational institute, higher secondary institutions like, so if you're working for a college as a professor, then you would not be counted towards the cap. Or if you're a non-profit hospital and you are associated with an educational institute, for example, if you're a CUNY hospital, say, and you're educated with the medical college as well, then it won't be considered to be H-1B cap subject. So in order to apply for a H-1B visa, first what needs to be done is the job needs to be decided. So the employer has to tell us what the job is, and the job duties need to be properly defined. This is all the groundwork that you do first. Then you have to make sure that whatever job is being given and whatever the duties are, that the beneficiary actually has that degree. Say, for example, it's a software engineer job. We have to make sure we get proper duties from the company. We can't just say design, develop software. That's not enough. You have to explain what the duties entail, so that USCIS or the officer that's reviewing the case can make a decision as to whether they're complex, the duties are complex enough to require a bachelor's degree in computer science. So the duties have to be flushed out. Then we have to make sure the beneficiary has a computer science degree or an IT related degree. Could be information systems, computer science, or some related technology degree. So that's the third thing that you have to kind of look at. And then after those things are decided, you have to actually also, of course, make sure that the employer has a job for the person. So you can't just file based on speculative employment. The employer cannot say, oh, I'm going to file this H1, and once it gets approved, then I'm going to look for a job for this person. No. You have to be able to talk to the employer and make sure that they have enough work for that particular beneficiary. Say a software engineer, if they're a consulting company, then you have to get a PO, make sure they have a purchase order to show that they have enough work to work at the end client. If they're working in-house, then you have to make sure you're able to document whether it's a contract that they're working on for another company but working in-house, or they're working on a particular product. You have to document that product information and the ownership of the product, because they are USCIS is very suspicious about whether the job actually exists or not, because there have been a lot of cases of speculative employment. So that's another issue to look into. So that's another piece of document that you need to keep aside. In addition to the LCA, making sure the duties are correct, making sure the degree is related, and then making sure that there's a job. After you do all this, you have to then file the labor condition application. Labor condition application is something that's not filed with immigration, with the USCIS, but it's filed with the Labor Department. And it's usually a form, a 4 or 5 page form, which attests to the job. The Labor Department code is put on that job so that they can identify the job easily. The work site is on the job. If there are 2 different work sites, then that's put on as well. And of course the job title, and the signator, the contact person, and then that particular, and the wage, most importantly, the prevailing wage is on the job, and the offered wage is also on the LCA. So that LCA, before it is filed, has to be posted, where the company's other employees can look at it. So it has to be posted on either the company website as well as physically in the office for 10 days at least, 10 business days. So while it is being posted, the LCA can be filed. It's filed with the Labor Department, as I said. And it takes about 5 to 7 business days for the Labor Department to come back with the approved LCA. And once they do that, then you go ahead and include the LCA in the package, and then you have to fill out the I-129 forms. Now there's I-129, and there's I-129H supplement, and there is an I-129DC form. So all 3 forms have to be filled out, and there's varying information on all 3 different types of forms. The DC form has a lot of information on the employer, what kind of employer, how much fee would be required, how many number of employees that employer has, how many are on H1, whether they're H-1B dependent or not, that's one of the questions, and whether it's cap exempt or cap subject. The I-129 form basically has information about the beneficiary, the company, and what action we're asking for. Are we asking for an extension? Are we asking for a new H1, which we would in these cap cases, with reference to these cap cases. So there's a lot of information, and any typo can be fatal. So it's important to go through the form very carefully and make sure that whatever is on the LCA mirrors what's on the form as well, in relation to the wages, dates of employment, the job title, etc., the SOC code. So all that, it has to be the same.
Right.
So once you prepare the I-129 forms, you attach the LCA, you have to then also attach the degree copy and the transcripts, because we have to make sure that the person is qualified for the job. So we attach that. If they have a foreign degree, we also get an evaluation done of the degree to show that it's equivalent to a US bachelor's degree. So we get a educational credential evaluation done from a third party, and we attach that as well. We also prepare a petitioner letter, and the petitioner letter will have a detailed job description and how about the company and what type of business the company does, and that all the duties are mentioned, the job title, etc. So all that is flushed out in the petitioner letter. In addition to that, we of course include the passport copy, and if there is additional information needed, for example, if it's a change of status, then USCIS wants to see status information about the beneficiary. So they want to make sure the person is in status first in order to be able to file a change of status. Otherwise, the change of status portion of the H1 will get denied, and the H1 will get approved only for consular processing, which means they have to go out of the country and then come back on that H1. They can't file a change of status. So change of status information, if they're on an F1, is usually all their I-20s, their CBIS records, their of course the I-94 copy, and a letter from the university saying that they're in good standing if they're still going to school. Or if they're on OPT, then copy of the OPT approval, the EAD copy, employment authorization copy, to show that they are still invalid EAD, or within the 60 days grace period, whatever might be the situation. So that is status documentation.
Right.
These are all the different little parts that go into the actual package, but there are different elements to even preparing the package depending on what kind of H1 is being. When you usually apply for, you can only apply for a maximum of 3 years. So you ask for 3 years, and then after that, after 3 years expire, before it expires, you're allowed to apply for an extension 6 months before expiry of status, and you can apply for an additional 3 years. So in total, you can be on a H1 for a total of 6 years. However, there are exceptions to this 6-year rule. For example, if you have an I-140 approved, then you can apply for an additional 3 years until you get a green card. So there's an unlimited number of times that you can apply for the H1. So you can keep on applying for extensions of 3 years at a time, provided your I-140 is approved. Also, if 365 days have passed since the filing of your labor, or 365 days have passed since the filing of your labor and I-140, whatever the case might be, you can get then an extension of 1 year on your H1. So that's another way to get further extensions. Also, if you have remained outside the country for some period of time, you can recapture that period outside the country. Say in the last 6 years you spent 1 month every year outside the country on vacation, so you can recapture that 6 months, and then that might give you enough time to file a green card, or wait for your green card, wait for your I-140 which you filed, or labor cert which you filed. So that's the AC-21 rule, which allows you to get a H1 extended beyond 6 years. Also, another way is if you have spent your entire 6 years and then you leave the country and you stay outside for a period of 1 year, then you get a fresh period of another 6 years on H1, starting with 3 years and then extending to another 3 years. But when you're doing this, when you're filing for this, you will be counted towards the cap. So it will be a cap subject H-1B petition. There's two types of changes: material change and a change that is not material. So Labor Department and USCIS says if it's a material change, then you have to file a H-1B amendment. And recently there's been regulation stating that H-1B amendment is required if there is a change in work location, and that work location is beyond the MSA, meaning beyond commuting distance of the previous location. So if you're moving to a different state, for example, far away from California to New York, say, just to give an example, then you would have to file, if your work site is changed, then you have to file an amendment. Now say the duties have changed. but the job title remains the same, then you would not have to do anything. You can just continue. If the salary has gone up, you may not. It's a gray area, but if it's not a significant increase, you may not have to file any kind of amendment for that change. In addition to that, if say the number of hours have changed, in that situation, especially if it's going from full-time to part-time, meaning it goes from 45 to say 10 hours a week, then you might have to file an amendment because you'd have to because there's been a significant change in the number of hours, and you might have to file it as a part-time H1. So it really depends on what the change is. Another change is if your company gets merged with another company or sold to another company. This is in the case of M&As or mergers and acquisitions. In some instances, you may not have to do anything if all the liabilities also have been purchased by the new company. Then you may not have to do anything, but otherwise, in some other circumstances, you might have to actually file a transfer to the new employer. So it really depends on the circumstances as to what the change is.